optimize all of our time together today. So Dee, I'll let you go ahead and kick things off.
Fantastic. Hey, Ben. Hey, everyone. So as we look at a NAR update, I was at a legal webinar with our brokerage risk management attorney. So today we are going to be listening to their salient words of wisdom in terms of what to expect from the NAR settlement. They do a lot to help to assist in downplaying, reducing, and minimizing the misinformation that's out there. There's a lot of misinformation out there. Week over week, I'm going to try and help to dispel some of the misinformation that's out there. But this is about an hour presentation, so I won't belabor it. Let me go ahead and get it started. This is Bill Jansen and his partner. So Bill is one of the premier real estate attorneys in the state of California. And I've known Bill for, a couple of decades at least. But Bill and Shannon, who is his partner, Shannon Jones, will be sharing information with us. So let's go ahead and get started.
Let's start and talk about the NAR settlement. So next slide, please. So this is what we are going to go through today. This is an overview of our presentation. We're going to talk about the NAR settlement. We're going to talk about changes that you can expect. We're going to talk about what this means for you. We are going to talk about, Bill is going to go through suggestions of establishing your value and how you should potentially present the buyer broker representation or agreement. We are going to do a deep dive, as you requested, into the buyer representation agreement. Please keep in mind that we did, August 2022, we have posted a webinar on the buyer representation agreement. This is an update and a deep dive. We are, by the way, going to talk about the new forms release. We are going to be using a lot of the new forms. They are not finalized. But because of the significant changes in the buyer representation agreement, we thought it was important to start acclimating you and familiarizing you with what we expect to happen. We will provide another webinar, either June or July. We haven't set the exact date on the new forms release, so please put that on your calendar, that we will do that for you. We are also going to talk about some of the forms that are related to the BRBC, and then we will wrap it up. So without further ado, next slide, please. Let's talk about the NAR settlement. So about 10 days ago, well, let me go back a little bit. As you all know, Bill and I kind of predicted when this whole thing, after the Sitzer-Burnett jury verdict came out, we predicted that there would be a settlement. NAR has been working very hard on the settlement. A lot of the industry leaders have wanted this resolved. You've seen some of the individual brokerages have been reaching settlements. So now NAR has reached a settlement. Candidly, I know realtors don't like changes, but I think that there are some silver lining, or there is a silver linings to some of this. I was talking to a client last week, and he called and was asking questions about the NAR settlement. And I will share with you that at the end of the call, he was excited. He was really, really excited. He said, "Oh my God, this could be so good for my business. I can start representing buyers. I can lock in buyers so that buyers aren't being represented by other brokerages. I really think that I could evolve my business to the point where I can grow it in light of this." And he sees this as an opportunity. I am really hoping that you see this as an opportunity as well, because I do think that there are aspects of it that could be really beneficial to your business. Okay, next slide, please. Okay, so a settlement was reached. It is subject to approval by the judge, which we expect to happen in July. However, California Association of Realtors is recommending that realtors start acting as though the settlement is in effect. Why? Because the changes that are contemplated under the settlement are not going to happen overnight. You are going to have to start thinking about the changes in your practice and start preparing for that. And it is going to take a couple of months to do that. It's also going to take a couple of months to revise the forms and update them in accordance with the settlement. Everybody is predicting that the judge will approve the settlement. I will candidly tell you, after 35 years of litigation experience, judges want settlements. And the judge, if at all possible, when all parties agree to a settlement, it is very rare when a judge does not approve it, because the judges selfishly want cases off their docket. So we have every indication that this settlement will be approved, so you need to start behaving that way. Okay, next slide, please. We expect that the terms of the settlement will go into effect in mid-July of 2024, of course, subject to court approval. But as I just indicated, we do think that it is going to be approved. Okay, next slide, please. NAR is expected to pay $418 million over the next 4 years. Your dues, by the way, for 2024 will not increase. We don't know yet what's going to happen in the future. Now, I will share with you that I am getting a lot of emails from clients saying, should we withdraw from NAR? Should we withdraw from CAR? Our recommendation is no, do not withdraw. We will work through the issues, but the bottom line is most of your dues go to paying toward forms on for the CAR forms, the ZIP forms. 90% of your dues pay for the forms that you're going to pay for anyway, and you might as well get all the added benefits that CAR and NAR provide. Primarily, CAR has done a really, really good job, and Bill, in my opinion, of handling this. We think that June Barlow and Jenny Lee, who is the new general counsel at CAR, are doing a fabulous job of kind of navigating through the NAR settlement and making sure that our members, that CAR members, including BRM's clients, are properly protected. So our opinion is, at this time, do not contemplate withdrawing or canceling your membership. Okay, new slide, please. So the settlement includes a new MLS rule prohibiting offers of broker compensation on the MLS. Okay, think about this carefully. No longer will listing agents be posting what is being offered to a buyer representative through the multiple listing service. Okay, it will no longer be there. It will be a separate negotiation between a listing agent and a buyer's agent. Okay, next slide, please. Listing agents will be required to obtain a seller's written approval prior to any amounts being offered to the buyer's agents. Okay, so what we see in the field now is you have a listing agreement, and in the listing agreement, the seller agrees to pay 5%, 6%, whatever it happens to be, that you've negotiated with the seller. And then a percentage of that gets offered to the buyer's agent. Now, technically, the listing agreement is supposed to say how much is being offered to the buyer's agents. In many instances, buyer's agents don't do that, and they make a unilateral decision as to how much they're going to pay to the buyer's agents. That is going to be a breach of the settlement agreement, and it is soon going to be an ethical violation. So moving forward, one of the terms is that listing agents must obtain a seller's written approval prior to an amount being paid by being paid to the buyer's agents. This will be in the listing agreement. Bill, you have something to add?
Yeah, you just said what I was going to point out. When the listing agreement forms are revised with a June release, it will separate out in two distinct paragraphs how much is being paid to the seller's agent, how much is being paid to the buyer's agent. So just wanted to point that out.
And one of the, and you can say this is either good or it's bad. I tend to think it's good. One of the outcomes of all of this mess, as I will call it, is that there is going to be more dialogue with your clients. So if you're representing a seller, there's going to be more dialogue, and Bill's going to get into the specifics of this, but there's going to be more dialogue between listing agents and sellers, not only about the property, the market, what the list price could be, what the market's dictating, CMAs. But that discussion is also going to morph into a discussion about how much should be paid in commission and how much should be paid to the buyer's agent. And a lot of this is going to depend on the market, the price point of the property. Let me give you an example. If you have an entry-level property and a buyer is scrapping together every penny that they have just to buy the property, it is unlikely that that buyer is going to be able to afford to pay the buyer commission, which means that the seller is going to have to be prepared to offer that. And that is part of your coaching as a listing agent, is coaching the seller on what the seller should do in terms of offering the buyer's representative a commission to get the property sold. On the other hand, if you're talking about a $10 million property, a $5 million property, in those instances, it's more than likely that the buyer's agent the buyer can afford to pay their own agent. So that might be a different dialogue. And it also depends on the market. If it is a buyer's market, then a seller is probably going to have to pay a buyer's agent's commission. If it's a seller's market, it's less likely that a seller is going to have to pay a buyer's commission. So those are things that you're going to have to start thinking about and educating yourself on as to how to present those to your seller. And it will likely be presented probably during a listing presentation, would be my guess. Okay, next slide, please. MLS participants acting for buyers will are required to enter into buyer representation agreements, written agreements, prior to showing a home. So let me repeat this, because this is going to be completely different. Buyer representation agreements will now be required for MLS participants before showing a home. So, don't have the attitude any longer, well, I've been in this industry for 45 years and I've never used buyer representation agreements. This is one of those changes that we're going to have to get used to. If you are going to be an MLS participant and you're going to represent a buyer and you want to show a property, you need a buyer representation agreement. Bill?
Yeah, Shannon, it's interesting that in the settlement, they use the word before touring a home without defining what touring is. And one of the questions that comes up is, what about open houses? If you are holding an open house and a buyer is unrepresented walks in, you confirm they're not represented, and you start talking to them about this home or maybe working with you. Do you need a buyer representation agreement then? And does it make sense to sign the big long one that we have? CAR announced on Friday that they're looking to create a very shortened version for use at open houses. But just put a pin in that. That's something in the future that will be resolved. Remember, all of this actually starts per the settlement in July, but we're starting to move forward now. But again, things are just getting put together because the settlement isn't as precise as it should be in some cases. Thanks.
Well, I also think that, settlements like this, where you're changing the industry, we're going to have a lot of wrinkles to work out over the next probably year. I would imagine we'll start getting them all wrinkled out by late summer, early fall. But there are going to be a lot of things that the attorneys who are not out in the field practicing like you guys are, haven't thought about, that we're going to have to work out as we go along. Bill,
Yep.
something to add?
Nope.
Okay, next slide, please. Please keep in mind that we've said this, it has been ingrained in your brain, I know. Compensation is negotiable, and it's negotiated between the agents and the clients. We issued a tip on Friday about some of the postings that agents have made, and pointing this out. And I've gotten a lot of questions over the weekend about that. And I want to make a couple clarifications. Compensation is always negotiable. And you cannot post in the public forum, I only charge 6%, or my brokerage only charges 6%. Why? Because it's perceived to be an antitrust violation by essentially setting the market by saying that. So that is how it is perceived by the plaintiffs' counsels and how it's perceived by the Department of Justice and by the California Attorney General's office. So you cannot post that. Now, on the other hand, if you're a buyer's agent and you want to post, I will represent you for a flat fee of $5,000. That is different. You are not setting the market. You are talking about what you in particular do. Now, I want to be a little careful about how we put this, because there seems to be some misunderstanding about what you can put out there. Now, it is one thing for a brokerage internally to have meetings and talk about what the broker charges as a minimum in that brokerage. But you can't go out and publicize, we will only work for 3%. We will only work. You can't put that in the public forum and talk to other brokerages about that. Bill, any comments on that?
Yes, and I would just say in the comments on this presentation, please don't put in the comments what you charge, what your brokerage charge or are going to charge. The comments there are not, it's not appropriate to put them there.
Okay, perfect. Next slide, please. Okay, sellers may communicate. Now, this is an exception. You can't put the percentage that the seller is offering to the buyer's agent in the MLS, but you can put things that the seller is offering the buyer called seller concessions. So, for example, seller is offering the buyer $2,000 to be credited toward closing costs. That can be put in the multiple listing service after the settlement is finalized, so after July 2014, provided that those concessions or that offer is not conditioned upon the use or payment to a buyer, broker, or buyer representative. Okay, next slide, please. Okay, to reiterate and provide you with more changes that you can expect coming up, offers of compensation will no longer be displayed in the MLS or the public feed. One thing I want to note for you is that ever since about November 2023 and the current, the MLS is now allowing you to put 0% for buyer's agents. However, that will go away. And there will be nothing offered. Okay, next slide, please. What does this mean for realtors? What does this mean for you? How is it going to impact on you? Next slide, please. You need to start acting as if these rules are going into effect in July. And what does that mean? Well, as I mentioned, or I touched upon earlier, you need to start preparing how you are going to discuss this with sellers. By the way, I am sure you have observed that sellers, there is a lot of publicity affiliated with this. It's not just publicity in the industry. It's not just Inman. NBC, CBS, even Good Morning America. They are all talking about the outcome of the Sitzer Burnett case, and they're all talking about the settlement. They're all speculating. A lot of that speculation, by the way, in our opinion, is incorrect. Nevertheless, you are going to have sellers and buyers that are going to start asking about this. Your sellers are going to start asking. In fact, I got multiple times last week, sellers asking, do I have to pay a buyer's agent? So you listing agents need to start preparing for that. You need to start thinking about how you are going to respond to that question in an informed manner. And what does that entail? Well, it entails understanding your property, understanding the market, understanding potential buyers and their ability to pay their own agents. On the flip side, and Bill's going to get into this, buyers representatives, you are going to start having to prepare, start learning how to use the buyer representation agreement, start learning how to prepare that and present that to your clients. And Bill's going to get into that in a few minutes. And you should start using the buyer representation agreement. Start getting used to that. Okay, next slide, please. The posting of offers of compensation to buyer's agents on the MLS is going to terminate. It will end, as well as MLS communications regarding seller credits or compensation or concessions. So offers to buyer's agents conditioned upon the use of payments to a buyer representative. So negotiations regarding compensation between a seller and a buyer's agent through the listing agent are going to be handled separately. And you're going to have to start getting used to those communications and how you are going to talk to each other with regard to those communications. Okay, next slide, please. Despite what is on the, or what cannot be on the multiple listing service, listing agents will be able to advertise in the media, on flyers, on their own websites. Now, this will not be on MLS affiliated websites, that the seller is offering a specific percentage or amount to a buyer's broker or representative. So listing agents moving forward, if you have had a discussion with your seller and your seller has said, I want to offer 2% to a buyer's agent, you will not be able to put that in the MLS, but you will be able to put that, for example, on your website, or in your marketing materials, or in your brochure that you hand out at open houses.
So I just want to point out, there's when it's talking about seller offering of a specific amount to buyer's agent or buyer's broker, it can be one of two types. It could be that you, in your listing agreement, have negotiated with the seller that in addition to the amount that the seller is going to pay you for representing seller, the seller's willing to offer a percentage of the sale price to the buyer's agent, and that's perfectly legal. It just cannot be mentioned in the MLS. So if you're advertising, as Shannon just said, in any of these other medium or formats or platforms, it would be wise to announce the seller's offering X% to the buyer's agent, or if the listing has said that the seller's already authorized you to pay the buyer's agent as the listing broker. In other words, you broker to broker compensation, you would put in there, seller has authorized listing broker to offer X% to buyer's agent. And if you on the buyer side can't tell which one it is, because the way you approach, and we'll get into this in the next segment, the seller on how that compensation works, or the seller's agent, how that compensation works, you're going to need to know what has been authorized on the listing side. We'll get into that in a minute.
Perfect. Thank you, Bill. Okay, next slide, please. Signed buyer representation agreements are going to be required before showing homes, or as Bill said, in the settlement, touring homes to a buyer. However, if you're going to go out, I think it is crystal clear that if you are planning on showing a home on the MLS to a buyer, you are going to need a buyer representation agreement. It is strongly recommended that you start getting used to using the buyer representation agreement and start using it now. Many of your competitors are doing that, and they are seeing it as an enormous opportunity. I will share with you the way that I look at this. We have, as long as I can remember, I've been in the industry now about 35 years, as long as I can remember, actually since 1988, believe it or not, as long as I can remember, sellers signed listing agreements. And the NAR Code of Ethics specifically says that when a seller signs a listing agreement with a listing agent, no other agent can interfere with that agreement, and you can't talk to that seller, you can't start soliciting that seller, etc. This is the reverse. This is the converse. So now you have buyers signing buyer representation agreements. It means they are locked up with an agent, just like a seller is locked up with a listing agreement. And that buyer is now has a representative and is off the market, so to speak. So in other words, is no longer available to everybody else as a client. So given that, and given that you are very used to doing this on the listing side, think of it as what you are used to. You're just now locking up a buyer as your client. And candidly, for whatever it's worth, real estate agents, just like Bill and I, the only thing that you have to sell is your time. And you devote inordinate amounts of time to buyers, trying to find the right property, showing them properties, sending them information, trying to educate them, trying to understand their wants and needs. You should get compensated for that. And buyers need to appreciate everything that you have to offer. Bill's going to get into that in a little bit more specifics in just a few minutes. Next slide, please. All right, next steps in realtors' communications with clients regarding their relationships and compensation. This absolutely, I mean, it means you're going to have, as we said, you are going to have more dialogue with your clients. There is going to be more transparency, whether it is representing a seller and taking a listing. You're going to have more discussions about compensation, what you're getting paid, what the buyer's agent is getting paid, if anything. On the flip side, buyers, representatives, and agents, you are also going to have more dialogue with your clients about what you do and why you have earned your compensation and how you get paid. All right, next slide, please. Remember the code of ethics? I just made reference to that. Prior to entering into a representation agreement, you have an obligation to make reasonable efforts to determine whether or not there is somebody else representing the client. You know, if you are now, and this is going to be the discussion that you have an open house and you're the listing agent and you have a buyer that walks in. And you have always in the past said, are you represented by anyone? Do you have an agent? Do you have a representative? Now it's going to be a second question. Do you have a representative? Do you have a buyer representation agreement? So you need to start training yourself that is the next question. If a buyer says, yes, I do, then you know that buyer is already represented by another agent and you need to treat that buyer as such. And remember the code of ethics of not interfering with that other agent's relationship. Next slide, please. So here is the dialogue that I just touched upon. Are you working with another agent? Do you have an agreement with that agent? May I see a copy of that agreement that you signed? Now, here's why you want to see a copy of that agreement. Number one, you want to make sure that the agreement hasn't expired. Surprisingly enough, a lot of times agents have buyer representation agreements and maybe they expired. Or maybe that buyer representation agreement does not apply to this particular property. Maybe the buyer representation agreement says that it is only for San Francisco proper. And the agent is looking in Marin, or the buyer is looking in Marin County. Well, it might not apply. So you do want to take a look at that agreement, ask to see it. Okay, next slide, please. I got a little bit ahead of myself as to asking for a copy of the buyer representation agreement. You want to see if it expired. You want to see if it's in effect. And you want to see what type of property or geographical area it applies to see if it's going to apply to your situation. If you have questions about whether or not a buyer representation agreement applies to the property or your circumstance, bring it to your manager and talk to your manager about it. Okay, Bill. I think you're taking, giving us thoughts, further thoughts on canceling the buyer broker agreement and
Yes,
handling.
okay, I'll jump on this one. Yeah. So to follow on to what Shannon just said, if you're talking to a buyer and they've got they've signed an exclusive agreement with another agent and they want to cancel, you cannot assist them in getting out of that contract. That's interfering with contractual advantage. It's a tort. It could have monetary and DRE consequences. So you'd have to tell that buyer that if they are not happy with their buyer representative that they've signed, for example, an exclusive agreement with, they should talk to a qualified California real estate attorney. That's what the QCREA stands for, Qualified California Real Estate Attorney, about whether or not they have grounds to cancel. Next slide, please. So let's talk about the steps that you need to take now before you present the buyer that you're talking to, the prospective buyer you're talking to, a copy of the buyer representation agreement. A lot of agents make the mistake of the first thing they do when talking to a buyer is pull out the buyer representation agreements and ask them to sign it. And the buyers are reluctant, and for a good reason. They may not know you. They don't have the trust that you're the person of all the people out there that I should sign this agreement with. So the steps are, how do you establish that trust? And it's essentially a two-step process. First, you have to spend time understanding their needs and wants so they know that you understand them. And then you explain your value proposition, which you do all the time on the listing side, but most agents aren't particularly good at it in dealing with buyers. So let's take a dive into what this looks like. Next slide. So buyers' needs and wants. Ask the buyer what it is you're looking for. Get past the 3-bedroom, 2-bath, close to commute traffic or 20 minutes from work, good schools, whatever the sort of physical manifestations of what they're looking for. Get into what's your past history with buying and selling homes? Are you brand new, or have you had some experience before? What was that like? Do you have any particular concerns? There's a questionnaire coming out from CAR, and let me talk about that in a minute. Next slide, please. The best question to ask, which you should always do when you're dealing with any client, this is true whether you're selling real estate or you're selling anything at all. What are you looking for in the person you're going to be working with? What are you looking for in your agent? Ask them to tell you what they're looking for, and then take notes. So you understand quite exactly, and then repeat back to them when you get to the next step about value proposition, your value proposition for the buyer, that you heard them and are commenting back to them on what it is they are looking for in an agent. Now, CAR is coming out with 2 forms for this. One is a buyer financial and personal information form, and another one is a buyer identification of preferences and priorities. CAR put these on 2 forms. I've seen them in draft form, and I think they've got a long way to go. I would be unhappy with them if this is what they look like.
Dee, did something happen to the video?
Yeah, I'm trying to see what just happened. I'm not sure what. Give me 1 second, okay?
No worries. I wanted to make sure that it wasn't just happening on my screen.
Yeah, I'm not sure what just happened.
Sorry, everyone. Just give us 1 second while we figure this out.
With. What are you looking for in your agent? Ask them to tell you what they're looking for, and then take notes. So you understand quite exactly, and then repeat back to them when you get to the next step about value proposition, your value proposition for the buyer, that you heard them and are commenting back to them on what it is they are looking for in an agent. Now, CAR is coming out with 2 forms for this. One is a buyer financial and personal information form, And another one is a buyer identification of preferences and priorities. CAR put these on 2 forms. I've seen them in draft form, and I think they've got a long way to go. I would be unhappy with them if this is what they look like when they're released in June, but hopefully they can make a better version of these forms between now and then. But basically, you want something in writing where they have told you what they want. That does a couple of things. It fulfills your fiduciary duty to learn. This is what fiduciary duty is about. Learn what your client needs to know to make an informed decision, because you are learning by asking these questions. And the other part of it is it has a fair housing component, because if they're telling you in great detail what they're looking for, you avoid the argument that maybe you were steering this particular buyer to a particular neighborhood based on maybe subliminal preferences or prejudices you may have about whether that client should be in this neighborhood versus that neighborhood. That's called steering. And if they're telling you and it's in writing, you now have documentation that it was the client that chose where they wanted to live, not anything that you just created out of your own interpretation of what they might like. Next slide, please. So then when you get to your value proposition, so are you dealing with an inexperienced buyer or a very, very experienced buyer? In other words, someone who's bought and sold homes and kind of knows their way around the transaction and the forms. If they're not sophisticated, share the process, go through the detail with them. And what are the timelines? What is it going to look like? Answer all their questions. You know, this is what a lot of new first-time buyers have, but don't assume that everybody knows it, because if someone hasn't bought a home for 5 or 10 years, a lot of things have changed. So take your time, sit down with them, spend time with the buyers. Next slide, please. For inexperienced buyers or buyers who haven't bought for a while, have the documents that they're going to be looking at. You know, the purchase agreement. They're going to, you know, the transfer disclosure statement, the SPQ, contingency removal, a lot of the advisories. Spend some time going through with them, and what you're doing is demonstrating your knowledge of the transaction. And all this time, you're gaining the trust of that person, and they're not going to sign that buyer representation agreement until they cross that threshold that, yes, you're the person that I'm willing to work with on the biggest transaction in most people's lives. Next slide, please. So, and then identify the tasks that are going to be performed and who's going to perform them. So you're setting their expectations. In other words, I have a transaction coordinator, and the transaction coordinator is going to be communicating with you about this. I have it, maybe it's a team, and other team members may take this part of it. You're going to meet even though they're not affiliated with your brokerage, you're going to meet the loan broker, and I'm going to introduce you to a loan broker that I have confidence in. So you're managing again their expectations about what this looks like, and it creates a comfort level that client is going to have when you go to the next step of talking to them about signing a buyer representation agreement. So then prepare what I call a buyer representation program. This is not a CAR form. This is something specific to you, customized for each buyer, that explains to them what you will do specifically if they decide to work with you. And also give it a name. One of the things I learned many years ago in marketing, that it doesn't exist unless it has a name. So give it a name. So let's go to the next slide. And I'm sorry, I went past this slide. Next slide, please. Yes, so we've created a template example for you of what that might look like. This could be like Bill Jansen's exclusive buyer representation program, or some people call it like a 10-star or a 5-star program, or a name that emphasizes who you are. And then you say, my responsibility, if you work with me, I will do the following. And these put some examples of things in there that buyers agents do. NAR has a list of 172 things that agents do for their clients. Do not give them that list. You're not going to do all of those, and that isn't specific to you. But you can look at that list to see maybe these are the ones that are part of your skill set that you use when you're working with buyers. Put them in there, and then the ones you know you're going to do on every transaction, leave some spaces at the bottom and fill it in with things that the buyer told me it was important to them, what they expect from their agent, and put those in there that I will do these for you. And then their responsibility is you're going to want to say when they go out and look at property that if they see something they like, they'll let you know, and also let them know that they're going to walk out, they're going to run into maybe listing agents who are going to try to recruit them to work with them. But if you got a buyer representation agreement exclusive, that they're working exclusively with you, explain how that works. Give them some of your cards. I call it inoculating the buyers against the aggressive listing agent, for example. So you're setting it up them to understand how to work with you. Next slide, please. By the way, you can use this. This is being recorded. We will send out copies of this the slide presentation. It will be posted on our website and available for managers to access. So the buyer representative program, advise them that you own, and I've seen this with agents who've been very successful working exclusively with buyers that sign buyer representation agreements. They say, after doing exactly what we just talked about before, setting the groundwork for that buyer to trust you, say that, I only work, as Shannon said, you're not selling houses, you're selling your time and professional services. And the implication of what you're telling them is, I don't give this away for free. It's valuable. I'm a professional. You're setting yourself up as a professional because this buyer now meets your criteria to work with them. I only work with buyers who agree to work exclusively with me. And if you agree to work with me for X number of days, maybe pick a short period of time because it doesn't feel like they're getting married. This is sort of like, well, we're going to have a trial period here. If you work with me for the next 30 days, I will provide you with all of the service in my buyer representation program. And if they agree to work with you, next slide, please, advise them at the end of that period, either party can cancel. And then ask the buyer to sign, or you can choose to renew. And then ask the buyer to sign the program and a buyer representation agreement. And then you pull out the buyer representation agreement, because this program, buyer representation program that I just discussed, will be part of what they will walk away with. They'll walk away with the buyer representation agreement and a completed buyer needs and wants assessment. So next slide. I want to get to this next slide because here's the important piece. You've told them what you're going to do, and now you have to keep your word. And one of the things that I like about this is I'm an optimist, and I think this is going to raise the level of performance of buyer's agents, the professionalism of buyer's agents, because what am I going to do for that next 30 days? I'm going to make sure I do all of those things because I want to talk to that buyer about signing up maybe a 90-day or longer buyer representation agreement with them, because now we've got a deep trust level established between the two of us. So this is an outline of how I've seen buyer agents work. Shannon?
No, I'm just anticipating
jumping
in and diving into the buyer representation agreement. So I'm
okay,
sorry.
and I'm sure there's gonna be a lot of questions on this, but again, put them in the chat. I'm seeing lots of questions in there. And again, as Shannon said, we'll get to them probably in the tip next week. Next slide. Shannon, this is yours.
It is. All right. So this is what you guys asked for. You asked for a deep dive into the buyer representation agreement. We went way over our time limit on the NAR settlement, which, okay. So we're going to get as much done on the buyer representation agreement as we possibly can. So next slide, please. We are using, and that's why you're seeing all the red, this is the revised buyer representation agreement that is going to be released in June. We are anticipating that the agreement will look very similar to what we're presenting to you here today. So that's why we're using this. There might be some additional tweaking, a little bit of changes. We all know that there's the April meetings, and so the Forms Committee is probably going to meet again before this is finalized. But we are presenting to you, and as Bill said, we will make these slides available to you so you can see them. We are presenting to you the most updated copy and really what we expect to see. So as you can see on the first page, we're now putting this in the form of a chart, very similar to the RPA. So it's following the same format in terms of the chart. If you look at paragraph 2A1, it says representation period beginning on and ending blank. Please make sure that gets filled in. You need to have timeframes filled in. It is a DRE violation for an agent to have a representation agreement with a client and not have end dates. Please also, although there is no specific rule on an end date, keep in mind that the California legislature in January said listing agreements can't be more than 2 years. So I would kind of probably use that as a guideline. It's not a law. But I wouldn't put 10 years in there. I think that that's probably somewhat unreasonable. Okay, the type of representation, is it exclusive or is it non-exclusive? It defaults to non-exclusive. So you have to mark the box if it's going to be exclusive. Please make sure that you mark the type of property that you are showing. You know, if it is land, you're going to mark other. Well, there's a vacant land, there's commercial, there's tenant in common, single family residence. You're going to want to mark those boxes. For location, you're going to put the location. Please don't put anywhere in Northern California. You want to make sure that these agreements are enforceable, and unless you are specific enough that somebody could identify what you are talking about, the geographical location, I think you want to be specific enough. Probably best to put a specific county or a specific city in there. But as I said, saying all of California or all of Northern California probably is going to put you in a position of having a relatively unenforceable agreement. You might want to attach a piece of paper that specifically identifies the particular property. If you are intending to show particular properties on there. I really encourage you to try and be as specific as possible, but still protect yourself. There is, as you get down, section D talks about compensation. So it's going to be 2D, talks about the amount of compensation. And then it talks about payment to third parties, compensation, right to compensation with the broker involved. For the broker involved, you're going to want to make sure that you have specific discussions with your clients. There is a cancellation notice. Now, please keep in mind that you will have an exclusive period, just like on a listing agreement. So if you have shown buyer properties and this expires or it terminates, you want to mark the box how many days after, if that buyer buys that property, you will step in and represent the buyer. Bill?
Yeah, so if you have a non-exclusive agreement, it's cancelable at will. Or there's a checkbox there, X days after receipt of the notice of termination. But if you have an exclusive agreement, even though it is for a longer period of time, it's cancelable after 30 days, 30 days after a notice of cancellation. Why is that in there? What was the Forms Committee noticed with past practice on buyer representation agreements, sometimes agents were making a very, very long period of time and then maybe not being as diligent as they should, and the buyer's very unhappy and they're stuck in a contract with that buyer. So even on an exclusive, a buyer can get out after a 30 days notice if they're unhappy with their agent. And some people don't like that, but I can kind of see the wisdom on why that was put in there. Thanks, Shannon.
Sure. Okay, next slide, please. Buyer representation, page 2. This looks very different. If you compare it to the buyer representation agreement that is currently in effect, this looks very different. It is somewhat reorganized and there is a lot more information. Please read this when it is issued so that you are familiar with it. I know novel concept, actually read your forms, but I would strongly recommend that you read this word for word. Paragraph 4 has been added. It is a discussion of compensation to the broker. It says advisory. It's an advisory to the buyer. There is an explanation of non-exclusive representation. There's an explanation of exclusive representation. There's a timing provision. There is payment through escrow. And I want to point out H, which is the provision of disclosure of anticipated payments to broker by others. This is specifically referring to the seller, or if anybody else is going to be paying the broker. You want to make sure that you have gone over this with your buyer, and it talks about broker at the earliest practical time. I am envisioning buyers, attorneys asking if you ever wind up in litigation, did you have this discussion with your buyer? You want to make sure that you are very familiar with this provision and that you have a very candid discussion with your buyer about how much your buyer is going to pay you. That if the buyer is writing an offer on a particular property, that you have a discussion with the buyer about what the listing agent or what the seller is going to pay you and what the buyer, if any, has to pay you under the buyer representation agreement. It is going to be very important that when a buyer writes an offer, that the buyer fully understand who is paying your commission, whether it's the seller, it's the buyer, or a combination of both. And I cannot emphasize enough that you make sure that you document that discussion in writing. What does that mean? That means that you write your notes to your file, and I would strongly recommend that you write an email to the buyer that says, I am confirming our conversation regarding our compensation pursuant to this offer, and then you're going to reiterate exactly what you discussed. The seller has offered to pay or in the offer, you are asking the seller to pay 2% of my commission. That means you will be paying 0.5%, because under the buyer representation agreement, you agreed to pay me 2.5%. You want to make sure it is crystal clear and documented in writing that you have had that communication with the buyer. I am foreseeing, given 35 years of litigation experience, a lot of surprises by buyers when it comes down to the close of escrow, where the buyer sees the closing statement and sees 0.5%, 1%, whatever it happens to be, that the buyer has to come up with more money to pay their agent. And if they were not aware of that and they weren't properly prepared for that, we are going to have problems. And likely what I foresee is, if you have not done your homework and communicated with your buyer and managed your buyer's expectations up front, the buyer is going to ask you to take a haircut upon the close of escrow of your commission because they didn't understand it or don't have the money. And I would like to avoid all of those situations by having very open and honest and transparent conversations with buyers about who is paying your compensation regarding any particular offer that's being written. Bill?
Yeah, I'd like to thank, very good, Shannon. I'd like to point out a couple of things in here that you should be aware of. Going back up to 4B1, non-exclusive, it talks about how you get paid. So you get paid. In other words, you can't just have a non-exclusive. Give the buyer a whole list of here's 40 properties in the marketplace and give them a list. That doesn't qualify. You have to meet the definition of broker involvement, and there's 4 parts of it, and it's in that paragraph. And if a buyer buys a property that you spend some time with them on, and you don't have an exclusive, you got a non-exclusive agreement, and you want to be paid, you have to show that you met this standard in paragraph 4B1 of showing, wrote an offer, negotiated with the seller about regarding this buyer, etc. So read, excuse me, there's five factors. Read all 5 factors and understand them, and more importantly, document when you're working with the buyer as you do all of those. When you've got a non-exclusive, because that buyer may sign, you can sign any one of a number of non-exclusives, because the name itself means it's non-exclusive. They can sign 20 or 100 of these if they wanted to, but the buyer agent that meets the broker involvement test is the one that's going to owe the money to the agent. Now, you may have another agent who has some broker involvement, but you're going to want to be able to demonstrate. Not just say, oh, by the way, I showed the property to them 3 times. What days? Gee, I don't remember. You're going to want to have documentation. So it's going to be some discipline on your part regarding showing properties and regarding these 5 factors. And I would recommend you memorize them, have them written down, so you're dealing with them on a regular basis with each buyer. An exclusive, that's a lot easier. You're just basically saying, if you buy any property that's in the geographic area within this price range before it expires, I've earned a commission whether or not I even saw that property or talked to you about it. So that's
All right, guys, we're coming into time. So these documents that Bill is reviewing right now, Ela will be sending a PDF out to all of you so that you can review them more in depth. And then we will talk about them. Make sure to highlight them with a yellow highlighter if you have questions, and we will talk about them in next week's session. But I hope this was useful. I hope this was effective for most of you. Certainly, anybody have any questions as we look to wrap this up? Awesome. Thank you, everyone, for participating. Glad the information was useful. As always, we will keep everyone informed and up to date week over week as we hear new changes, as there's new information that comes aboard. You guys will be the first to know it. All right. Take care, everybody. Awesome.
Thank you so much, Dee. Have a great day, everyone.
All right.